let's say someone comes and says, look, I've got $100,000 sitting in the stock market. I want to move it out of there and invest it in oil and gas because I think I can get a better return. Okay, if that is what they're doing and they're maybe looking a little into it, they want to read on the internet about it, whatever, and they take that money and move it, I cannot imagine that anyone would say that that's a violation of status. And that really applies to any non-immigrant status if it's truly passive investing. And the analogy I'll give people on the phone is, when they call with consultations about this, is like, look, if you were to buy.
Hello, everyone. My name is Keshav Kalor, and welcome to today's episode, very special episode about investing for immigrants, specifically for those folks who are on visas. And so just to give you some background, my name is Keshav Kalor, one of the principals and founders of Clive Capital. We help busy professionals, primarily in the tech industry, from top companies like Meta, Google, Amazon, and more, invest into syndications, into private equity real estate, oil and gas, private lending for better returns, passive income, tax benefits, diversification, and more. And so far, we've helped our investors, again, mostly from these top tech companies, invest into over 1,100 apartments under renovation, 500 single-family rental homes under development, 13 industrial warehouses, 16 oil and gas wells, and private lending nationwide. And our Investing for Generational podcast, what you're listening to today, we like to bring on a variety of guests across personal finance, investments, taxes, legal structure, and just have them educate us about all these different avenues and considerations we should be taking into account when we're investing. So today we have a very special guest, Mr. Joel Yanovich. Today is joining us from the Murthy Law Firm. Joel, thank you for joining us today.
Thank you for having me. I appreciate it.
Yeah. So immigration's been a hot topic, especially in the last year or so, but even before that. And there's a lot of uncertainty that comes with being an immigrant, no matter where you are. And we're going to specifically focus on U.S. immigration here because that's what we know best. That's what Joel knows best. And its impact on investing. So Joel, if you could start us off with just a bit of a bio, a background about yourself, your experience, your firm's experience.
Sure. So I went to law school in Los Angeles at Loyola Law School of Los Angeles. I practiced business immigration there for several years, started learning about EB-5 and filing E-2 cases for treaty investors. A lot of L1s there are a lot of entrepreneurs that use the L1 category. And then in 2011, I moved here to Baltimore, Maryland, worked for Sheila Murthy, and I've been here ever since. Most of my practice involves either entrepreneurs or investors, so that's just the little niche I found myself into. We only do business immigration. We don't generally handle asylum removal type stuff, although unfortunately, some of that is creeping into business immigration, so we're kind of using it a bit. But for the most part, we're dealing probably with the people that you're listening to in the tech sector. That's by far the most prevalent area that I deal with. Some, physicians, things like that. Obviously, you need to be able to afford to do some of these investment visas. So these are typically the categories that I've been dealing with. So I do file a lot of treaty investor E-2 visas. Most of my clients are Indian, and they do not, because of their country of citizenship, they don't have access to the E-2 visa, but some of them will get citizenship in Canada or Australia or one of these countries that do have these treaties. So I have a lot of those clients. And then EB-5 is obviously open to anyone wanting to get a green card. And the people who are stuck in the green card backlogs by far the most right now, when it comes to employment base, are Indians. And so they've been picking up over the years for EB-5 a lot.
Thank you. So there's definitely a lot to unpack there. We'll probably do a whole separate episode just on EB-5s. But for today, I'm this is obviously a privileged question. I was born in India, but I naturalized when we moved here because we moved here when I was 1 year old. And luckily, my mom became a citizen when I was still a minor. So I did not have to go through a lot of the headaches that a lot of folks have to go through in our very complex immigration system here. So could you, for me and those listening, just break down, I think to start, the broad category of visas and
Mhm.
where they could all fall into? And
Sure.
I think I'll ask, and I want to start with that because, as far as I know, and feel free to correct me if I'm wrong, if you're a citizen or if you're on your green card here, permanent resident, then you don't really have any restrictions when it comes to any positions you can hold, any investments you can make, or any businesses you can start. Is that correct?
Yeah, so citizens for sure don't. Green card holders, the only restrictions I'm aware of are there are certain employers that require citizenship, but typically that's going to be like a government entity that requires a US citizenship. If you need some kind of top secret level clearance, I believe you have to be a US citizen for that. But generally speaking, yeah, if you're a green card holder, if you're a US citizen, you can come and go as you please. Green card holders, maybe a little bit less so. And they can invest anywhere they want. They're not going to have any restrictions as far as that goes. Certainly not under immigration law. Um, so yeah, I think that in a nutshell, that's correct. Yeah.
Okay, so then let's focus on visas because it seems like that's where there might be a little bit of a gray area. If you could start out by just, I don't know, like how many types of visas are there? And then maybe it makes more sense to categorize them into broader buckets that are easier to think about based on restrictions, what you can do, what you
Sure.
can't do.
So yeah, we kind of say there's an alphabet soup of visas because there are just so many different categories. Most of them, though, when someone calls in, they're like, "Well, I'm on H-1B, or and I want to move to something else for whatever reason." It's not. We're not having an hour-long conversation about 30 different visa types. Most people, especially from India, but even from a lot of other countries, there's a very limited pool of work visas, assuming they want to be able to work. Um, that are available. So the biggest one by far, the one that people have heard about on the news, maybe in passing, is H-1B. So I would say a substantial portion of my investor clients were or currently are on H-1B. Um, it is, it's kind of the catch-all for professional and for professional positions. So it doesn't matter if you are in IT or you're a chemist or whatever, as long as it's a position that requires a minimum of a college degree in a particular field, that can be an H-1B job. So that's the big one. L1 is pretty, L1 is for intercompany transferees, so people who are working for a multinational organization, either as a manager or executive or what's called a specialized knowledge position, and they'll be transferring from their office in Tokyo or in Chennai or wherever it is, and they're transferring them to the US on the L1. Um, Beyond that, so I mentioned the E2, the treaty investor visa, which is, although it has the word investor in it and there is an investment involved, it's completely different from EB5, which is the green card category. So E2 and also E1, which is for treaty traders, um, these are very useful. They don't have a cap like you do with H-1B, which is one of the problems with H-1B is you have to get into H-1B in the first place through a lottery system. Although today they've announced the proposed rule that's going to potentially change that to a degree. Um, but the E1 and the E2, if you have citizenship in a country that has one of those qualifying treaties, then that's a pretty useful category.
And
T,
E1 is extraordinary talent, right?
no, 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 no.
Okay, what are E1 and E2?
E1 and E2 is treaty investor and treaty trader. The O1 is for extraordinary ability, which is the
Okay.
non-immigrant visa. And when I say non-immigrant, non-immigrant is basically anything that isn't permanent. So green card is permanent. So you can say an immigrant visa from abroad or here adjustment of status. Um, so green card holder, that's permanent, but the non-immigrant visa categories, and there some of them will have kind of the equivalent version of the green card. So for instance, L1A manager or executive, there is EB1C, which is all 95% identical, but it's for the permanent benefit. So O1 is for, extraordinary ability, people at the kind of top of their field. And then there's EB1A for extraordinary ability, which is the green card equivalent of that. Um, and other than that, there's the TN visa, which is only for Canadian and Mexican citizens, and it's sort of like H-1B in the sense that it's for professional positions mostly, but there's a set list of occupations. And so if you have Canadian or Mexican citizenship, that's a useful category. There's no cap, there's no lottery, any of that kind of stuff. It's a quick and easy it's probably among the easiest visas to get if it's a good case. Um, and I think those are really the main categories that we're going to deal with. You may have people on J1, which is like for professors, or some physicians are on J1. Um, and F1 obviously for students, but the categories that I mentioned are really kind of covering most of it.
Okay.
Sorry,
No, hey, little ones.
this is
Sorry.
yeah,
No
the
worries.
work from home is
Yeah. Pros and cons, but it's all good. So the broad categories again for working professionals interested in investing that we'll focus on is H1B, L1, E1 and E2, and then J1. Like those are the main ones, right?
Yeah, I mean, I don't J1 in the tech sector, you're going to see a lot less of. Certainly working for the big, anything. I've got a lot of clients that work for like Google or Amazon or what have you. It would be extremely unusual to see one of them on a J1.
Okay.
So just because again, the most common J1 that we see are J1 physicians by far. J1 physicians and to a much lesser degree J1 professors, neither of which are certainly not within the tech sector.
Okay, got it. Okay, that makes sense. So let's say that that's our conversation of working professionals, tech, physicians.
Well, and I can make it a little easier.
Yeah.
The restrictions or lack thereof for an H-1B worker or an L1 or E2, there's going to be very little difference between them. Uh,
Okay.
so if an H-1B worker can invest in a particular thing and it's not a violation of status, pretty much any non-immigrant visa category probably can do the same.
Okay. Okay, that's good to know. So now with that kind of laid out, how do you recommend these folks invest? What restrictions do they have when they're on visas? What can they do? What can they not do? Maybe let's start out with just a simple statement of the law, but then there's obviously gray areas and stuff. So then would be curious to hear what kind of edge cases that you've seen.
The funny thing is, it's mostly, I mean, substantially mostly gray areas because there is
Okay.
so little guidance on this. Uh,
Okay.
so I will get questions all the time. Every iteration you can conceive of, I've gotten these questions about can I do this while on H-1B, let's say.
Yeah.
Can I write a book and publish it on Amazon? Can I rent out for Airbnb? Can I drive Uber? So, and these kind of my answers will range from driving Uber, I think is clear cut. That would be a violation of status. And then a very common version of this is I want to invest in a business.
Yeah.
It might be investing in a friend's business that they think is going to blow up. It might be they have questions about day trading. They have questions about opening their own business, and all different ways this kind of comes about. Um, so the one part that we feel fairly confident being able to say is if you are doing truly passive investment. So let's say someone comes and says, look, I've got $100,000 sitting in the stock market. I want to move it out of there and invest it in oil and gas because I think I can get a better return. Okay, if that is what they're doing, and they're maybe looking a little into it, they want to read on the internet about it, whatever, and they take that money and move it, I cannot imagine that anyone would say that that's a violation of status. And that really applies to any non-immigrant status if it's truly passive investing. Um, and the analogy I'll give people on the phone is, when they call with consultations about this, is like, look, if you were to buy $20,000, $50,000 in stock at Apple, that's how much authority you have. No authority, right? You can show up to a meeting maybe and use those shares to vote, but you have nothing really.
Yeah.
You're not going to control anything. No one's going to accuse you of working for Apple because of that. It's a passive investment. And so whenever you're in that completely passive field, I've never heard of anybody getting pushback on that front.
So the one edge case that we talked about, I know you and I in our conversation, private conversation, we came to a conclusion on this, but since we're recording, and this is one of the big questions that, I have for my investors, a lot of them from these tech companies, a lot of them Indians, someone on one of these non-immigrant visas. And, in oil and gas specifically, all of our investments are passive, including these oil and gas investments. For the purposes of tax benefits, just in year one, they're classified as a general partner on their tax return rather than a limited partner. And what that means is, again, with a general partner, that typically means, like in real estate or other sectors, that you're actively involved in the business. In oil and gas, we're allowed to do that, obviously, to promote energy production here. And what that allows us to do is pass tax deductions on to investors to reduce their W-2 income. But they don't have to do anything passive. So reality is that they're passive. But on their tax return, it says that they're a general partner just for tax purposes, just for year one. So is that okay as long as, hey, they can prove that they didn't actually have any involvement in drilling or finding the deal or managing it?
Yeah, I would still categorize that largely as a passive investment. Now, again, there's no case law on this, but the reason probably there's no case law is it's hard to imagine an officer really taking issue with that.
Okay.
What they would potentially take issue is they see on paper it looks like maybe you're working. I've seen that come up before where I've had clients that there was some kind of documentation that looked that maybe they had started up this business and were running it prior to getting work authorization through a visa. So not exactly the same because in your case, they're never interested in working in oil and gas probably.
Yeah.
But at the end of the day, we're talking about both parties are on H-1B or what have you. They do not have work authorization for that particular business. And when that's come up, depending on the facts, I would present evidence that no, yes, they're listed as the CEO and they are the CEO, but they're not performing any work and they're waiting until it's approved. And here's the evidence of that. And thus far, I've never had a case denied on that issue. Obviously, we have seen cases of people engaging in unauthorized employment. And to be clear, that's really what we're mainly talking about. When we're saying a violation of status, it would presumably be based on unauthorized employment, which would be a violation of your non-immigrant status. So if you were, and the concept of employment is viewed very broadly. So if you are doing something for your own business, not getting paid, but you're doing it for your own business, that still could be viewed as unauthorized employment. If you were running things, if you were managing things, if you were involved in that. But so, again, paid or unpaid. But again, if all it is on paper, you are a partner. Now, how many partners are there? I'm assuming it's a bunch.
It's a bunch. Yeah, every investor gets classified as a partner. So previously, our capital raises were around 10 million or so. And so we may have, call it 100 investors at most. We're launching a $100 million fund now. So there'll be a lot, call it maybe even up to 1,000 investors.
Okay. Yeah, I mean, again, all of that, and you would probably get whoever it is that's actually running the company. In a perfect world, I would say, hey, can we get an affidavit from them explaining that, maybe we get a letter from a tax lawyer explaining the tax benefit and no, you don't actually have to be involved in the business. Maybe I show them the list of the partners, and you can see there's 100 partners on here. We're not
Yeah.
all involved running the show. We're just listed here for tax benefits. So I think the risk is incredibly low. I cannot imagine a scenario where an officer would even really push back on this. And if they did,
We do.
there's ample
Yeah.
evidence to show that you're not involved. So if I were not going to do this, I don't think it would be for this reason that I'm going to be violating status. You're just passively investing the cash.
Okay. So it's really what happens in reality that's really what matters, right? Like there has to be proof that you're not materially participating or, working for someone or something else unauthorized.
Yeah, I think that that's a fair statement.
Okay. That's like one of the big questions that I had, but now I'd be curious to hear about some of the more interesting cases that you come across, the book writing, starting your own business, being named as CEO, just so we can get a better handle on, hey, like these are some guidelines about how we should be thinking about some of these, all of these gray areas.
Yeah, so the CEO case was just kind of basically this person's information had been used to secure the company's federal ID, the FEIN. And so his name was on it. And the reason for it was that the lawyer just had the person's name and address, and it was easier to do it that way. And so when we got the RFE, we got an affidavit from the lawyer explaining, no, he's not, this is not evidence that he was working, and he explained exactly why his name was on there. And that was it. The other stuff that we get, like the book writing. So it's like, well, so I've told people, look, if you wrote a book while you were in India and then you came to the US and it was you had posted on Apple and you came to the US, I'm on Amazon and you'd come to the US and it's selling, I would view that as passive. Maybe you did work, but the work was done while you're physically outside the US. And if it's selling while you're here and the only thing you're doing is collecting, your royalty check, I don't think that's an issue. But the writing one is kind of interesting because it's like, well, what if you've never written a book and you write it while, like, for your pastime, and then you decide, you know what, I'm going to put it on Amazon. Was that work or was it a hobby? And there's no answer to this question. It's going to be, in the unlikely event that this came up, you would have to make the arguments and kind of go from there. I've never seen it. I've never heard of anyone seeing it, but I've been asked this question more than once. Then the kind of a common one we'll see is, and this is a good gray area question, is I have a house, and rather than selling it, we're buying a new one, and rather than selling it, I want to keep it as an investment. Can I rent it out? And so there's not a clear answer. I would say if you're involved day to day, you're the person they call to get stuff fixed. If you're the person having to, do the background checks, all that stuff, it could be viewed as work. So if you want to do that and you want to minimize your risk, I would say you hire a property management company. Let them do everything. The toilet breaks, they're going to call the property management company. At the end of their lease, if they leave, the property management company is going to find new tenants. And maybe you're stopping by once a year, in between tenants just to check things out. I would say that the risk in that scenario would be very low. I'm not sure how they would argue that that's employment. Versus the day, Airbnb in my house, and every weekend we get a new person and I have to go in there and clean, et cetera, et cetera. That I think is more likely to be considered a violation of status. But all of this stuff it's based on so little feedback from the government that a lot of times we're just like, look, if you want to do this, you do it, but there's a risk here. You can't say, well, I didn't know. That is not from an immigration standpoint, you have to prove that what you did was okay, not the other way around.
Got it. Okay. Okay. And then just for those who are tuning in, feel free to throw your questions in the Q&A and we'd love to get to them. Another one that I had, can folks, again, on non-immigrant visas sign on loan documents or provide, personal guarantees, backing loans from the bank
For like on behalf of the business,
on behalf of the business? Yeah.
I don't know. I mean, I say
If
that
that's
I
all
don't think
they did
anyone.
is just sign on a piece of paper saying, hey,
I would say again, this is, when I kind of view it as totality of the circumstances. You're going to look at all the evidence, say, is this going to be considered work? If the only thing the person's doing is, and a loan document, it's kind of usually a one-time thing, right? You're not every
yeah,
month you going in for a meeting to sign another document. Um, I would say that the risk of that is probably very low as well. Let's say you're one of um, so something that's very common is we'll have someone that wants to invest and be a significant investor in a business, owning, a significant portion, and they will have, let's say, a U.S. citizen or green card holder partner. who's running things, someone that they trust, or maybe it's a relative, so that they don't feel the need to look over the business. So in that case, so first of all, I tell them, look, they're going to be suspicious that you own a business, let's say 50%, and you're not involved in the business. And so you're going to need an answer to that. And one of those things I personally believe, if I were the officer, if you don't have someone that you have a reason to trust emphatically, like a very close relative or lifelong friend running the business, most people aren't willing to put a bunch of cash into a business and then sit back and then just assume that their business partner is going to, do right by them.
Yeah.
Um, so, in that case, so let's say they did that and then they're really not involved, but they need to get a loan. And because he's a partner, he needs the bank says, no, all the owners need to sign off. I don't think that is going to be viewed as work. Again, it's a judgment call, but we're talking about 5 minutes of quote unquote work. That's really just signing a document. That still to me feels relatively passive.
Got it. Okay. And then let's see, how do different stages, when you're working up to that H-1B or whatever visa you have, like when you're working up to those different stages, at what point do you like can someone feel comfortable making an investment? Would you
Uh,
wait until they have officially received it? Is there some sort of intermediate approval step where it's basically as good as receiving it?
like the H-1B approval.
Yeah, yeah.
Well, so the question would really be what status are they in while they're waiting for that?
Okay.
And there's various different ways. So the most common scenario is the person's on F1 and they're changing to H-1B status, and typically they're on F1 until they get to H-1B.
F1's the student visa, right?
Yeah, student visa, sorry.
Okay.
So in that scenario, the F1 student presumably would have the same rights to make the investment as the H-1B worker. So I don't
Okay.
really think we're gonna have much of a distinguishment there. Um, so the one piece of sort of guidance that we have is on a tourist visa, on a regular B1 visa, if you came here and said, look, I want to do an EB5 investment, or I want to do an E2 investment, there is something in the Foreign Affairs Manual, the FAM, that specifically says that is an okay, you're allowed to do that on B1. If you're allowed to do something on B1, in general, the assumption is you could do it on F1 or H1B because it's not work, quote unquote. I mean, there are certain things on B1 that I would frankly be more comfortable for the person to be on B1 than on H1B to do. But the investment, I don't think so, because again, that's going to be truly passive. Certainly most EB5 investments are very much passive investments. And again, the government, I've filed countless cases in that scenario and have never run to the government saying, well, how did you make this investment when you were here on H-1B?
Yeah.
So there's really no reason to think doing the same thing in oil and gas isn't going to be treated the exact same way. And keep in mind, I always tell clients, you never lie to the government. Never lie on immigration at all. But
Yeah.
you also don't have to disclose stuff that's not asked. I don't know that they're going to even be aware of this. It's possible that people are going to have to start submitting tax returns. Um, we're going to have to see how things go. But it's very possible that the government's not even going to notice, or potentially not even have the documentation to know this person's a partner in oil and gas. So it's not about hiding it from them, but
Yeah.
you're under no obligation to say, hey, oh, by the way, can you double check this and make sure what I did wasn't a violation of immigration law?
Yeah. Got it. Okay. Okay, that makes sense. Let me see what else. Besides, tending towards only, you know, limiting your involvement in any investment, any business, any venture to as passive as possible, whether it's just putting up money or just signing a document here and there or checking in once a year. Are there any other common pitfalls that you commonly see, people risk their non-immigrant visa status with in the
I
world of
mean,
investing, and then how they should avoid
yeah,
that?
I mean, the biggest one I would say is kind of a general issue is people doing things and then telling their immigration lawyer after the fact. And sometimes way after the fact, where it's like, there's nothing I can do now. If you told me 2 years ago, or even, 2 days ago, whatever, depending on what the situation is, I've seen that plenty of times where it's like the person has kind of just dug themselves into a hole, and maybe you can get them out of it, but it's like if you had just made a phone call or sent me an email, I would have told you just do this instead and it'll be fine. Um, so what I would say is if you don't know, if you're not sure, check with someone that does know. Check with your immigration attorney. Some of this stuff is very easy. It's a very simple, 2-minute conversation, but it's better to have that proactively than find out after the fact. Because this is not the whole idea of, it's better to ask for forgiveness than permission. I don't think that works in immigration law.
Yeah. Okay. Are there any other common, maybe like a couple more examples? Like I know on the spectrum you mentioned driving Uber is a no. Writing a book is, probably leaning towards no, but as long as you do it outside the country and you just collect passive income now, it makes more sense. Renting a property is a bit of a gray area, but any other common use cases that'd be good for to help, more
Yeah,
training.
well, first off, so you kind of reminded me of something sort of related, which is people think they need to get an H-1B. So they're going to India for 3 months for family reasons. And their employer says, you can work, you can keep working from India. And they're like, well, do I file an amendment? And so one thing that comes as a surprise to a lot of people I speak with is US immigration law doesn't apply if you're not in the US, as a general rule. So you don't need any kind of work visa to work from India. Um, and this is very common. So when you're saying writing the book in India, I would say the chances of them saying that's a violation of immigration law is practically zero. Because how could you violate your status if you're not in status, if you're not here?
Yeah.
We did run into a case very recently, and just to be clear, within the last several months, we've started seeing things we have never seen before. No one has. Just completely unprecedented stuff in immigration. And one of them was someone there was a few accounts of people working from India for a while and then trying to come back in and being told they can't because either too much time had passed, like 90 days, and one of them the officer said that, oh, you didn't file an amendment to work from Chennai or whatever. And it's like, you can't, the system won't even let you file for another country. It's impossible. And certainly there's no immigration law requirement. So when I'm giving these rules, keep in mind that every once in a while, you will run into an officer that's just poorly trained and it can create catastrophic problems. But it's not because immigration law you violated immigration law. It's because you ran across somebody that didn't really understand it and made a mistake. That being said, um, other scenarios, um, the rental is the most common, and then the investing in corporate companies is, those two are the ones that I hear more than anything. Um, I want to develop an app. So that's a common one too. They're going to develop an app and they might be doing it just as a hobby. And then after they've developed, they're like, you know what? We could turn this into a startup. And then it's the question of can you do that? And I kind of put that like the book. It's like, well, I don't know. I would say that you weren't working for a company, anything like that. Could developing an app on your free time where then you decide, eventually that you're going to sell it or try to license it. I I would be concerned, but I've never seen it come up. I've never heard of it coming up, and um, that's just kind of one of those areas where, like, look, you're going to have to be comfortable living in a bit of a gray area.
Yeah. Okay. I mean, to me, it seems like once you do want to turn it into a startup, at that point, it's clear you're working for someone else and not your
Yeah,
authorized
but
employer.
there are so in January, one of the last regulations to go in effect before Trump took office, they changed the rules to make it easier for H-1B workers to file for their own H-1B. So if they wanted to start a startup, um,
Mm,
they very well may be able to. We filed a number of these successfully without really much issue. Um, but yeah, that part where they're like, I already have the app, I'm ready to go, I'm just doing the startup. I can answer. Yeah, you can file the H-1B, but if they start asking questions about, well, when did you develop this app? You haven't left the country in the last 2 years.
That
It could
makes
be an
sense. Okay.
issue, possibly.
Got it. Okay. So as it stands now, you can file for your own H-1B if you were to start your own business?
Yes.
Okay. Okay.
If it's a professional position. So if you're starting in McDonald's, you're not going to be able to get an H-1B through that.
Okay.
But if you're starting an IT, type thing, and most of your work is going to be spent doing the IT part, and some of it's more of like fundraising and meetings and stuff like that, that is very doable.
Does it have to be, when you say it has to be professional, does it mean it has to be linked to your education? Like what does that mean?
So immigration defines professional in kind of the simplest terms is it has to have it must be a position that requires a degree in a particular field.
Okay.
Now, if you have, let's say you have a chemical engineer, I'll go back to IT, but let's say you have a chemical engineering position,
Yeah.
degree. If you and you're working in India for years and years in tech, even though you have the chemical engineering, you can have enough experience to be the equivalent of a degree in a particular that degree, and you can get there are these equivalency organizations that will say, "Yep, you have the equivalent of a computer engineering or whatever."
Okay.
It doesn't have to be related to your field of education, but it usually is, or at the very least, you've been working in that field for a long time.
Got it. Okay. We had a question come in. Can you talk a bit more about the E2 investor visa and how investing on that differs from H1B, TN, etc.?
So E2, there's basically there's a few different ways E2s are filed, or groups or people that file E2. So you have everything from, let's say, very large corporations. So I'm going to use Honda as an example. Honda is not my client. I've never worked for a Honda client, but I'm pretty certain that they have an E2 registration at the consulate in Tokyo, where they can send their executives and managers to the US. So those are kind of the big companies are going to have are likely to have an E2 registration. More commonly, what I'm dealing with are individuals starting their own company. So unlike H-1B, where it has to be professional, or TN has to be one of these kind of set occupations, E2 can be for pretty much any kind of business. Um, so I was talking about the different kinds of E2s. You've got the big corporations, you've got the individual investors, and then you also have the employees. So going back to Honda, the investor is going I don't know who if Honda itself invested in the US. Probably that's what happened. So Honda is kind of the investing entity, and the employees who've never invested at all, they're eligible as E2 employees, managers, or specialized workers. But with E2 investors that want themselves to go, they will invest in their own business. Let's say they could open up a pizza pizza joint. They could open up pretty much anything, any legal business, with very few exceptions. And um, based on that investment, they can apply for the E2. So it's a completely different animal than the H-1B. Usually you're filing the E2 at a consulate instead of with USCIS. And for most countries, you'll get a visa that's valid for 5 years, and you can kind of come and go as you please during that time, working for that business, for your own business. It can get a little bit more complicated when you have more than one investor in the business. Um, you wouldn't, yeah, and again, you have to be coming here to oversee that business, to direct and oversee that business. So you wouldn't do it. The gas investment's not going to work, obviously.
Yeah.
It does have to be majority owned, or at least 50% owned by the treaty country, or citizens of that treaty country. So if you were, let's say, a Canadian citizen, a minimum of 50%, but a lot of these are for a new company is just going to be 100% the owner, and they're applying for their own E2. And then potentially later on, they could also do E2 employees for other people from Canada, or whatever their citizenship country is.
Okay, so it sounds like if you got the E2 from a large multinational corporation like Honda, for example, you're bound by the same rules as an H1B investor, for example, as far as like investing into something that you're not directly leading yourself.
Yeah, well, either way. So whether you're coming as an employee of a corporation, or let's say you're an E2, the E2 investor,
Hmm.
but as the E2 investor, you then want to make the investment in the oil and gas field. Um, there's no reason to believe the rules are going to be any different for the E2 than they are for the H-1B worker. There's nothing in immigration law that really distinguishes them in that respect.
Got it. Okay. We have about 15 minutes left on top of the hour. If anyone has any questions, continue to throw them in. But in the meantime, with all the news that's come out recently, it doesn't directly impact us when it comes to investing, but we'd love to hear about your take on it and how it might affect people. And again, just good practices in general.
Yeah, so this is brand new. The H-1B one, which is it's $100,000 fee to the company for every new H-1B worker. We wrote 3 articles within 24 hours because the information just kept changing. So at first we kind of posted confirmed rumors, and that it was for the employee had to pay for it, and then it was no, the employer, and then it was like, well, only the new ones, and so there's a lot of unknowns here. I I mean, it's going to be challenged in court. I wouldn't be surprised if those challenges are successful and no one ever pays this fee, but who knows? So, as of right now, as best as we can tell, it's going to apply to new H-1Bs. One of the big questions is, well, what I'm working for Amazon and now I'm looking to change employers to Apple. Does that mean I have to pay, that Apple has to pay the fee now? Um, Nobody knows the answer to that question yet, or at least no, if anyone knows in the administration, they're not talking. Um, and if you read what was written in the executive order, it doesn't say what they're now saying it says. It basically said it applies to everyone, and now they're like, no, no, no. I strongly suspect they got a lot of feedback from some friends in those big corporations that are going to be mostly impacted, and they decided, well, we'll at least tamp it down a bit. Um, so at this point, it's kind of wait and see. I'm telling most of my clients, or the people that are on H-1B, it appears you're unlikely to be subject to it. I can't tell you whether you should travel or not. If it's important travel, you need to do it, then do it. Um, if it's non-important travel, you still should theoretically be fine, but there are some unanswered questions. So a good example, I've got a client now that they have the visa in their passport, the H-1B visa. They're working for the same company. They're just going to like a wedding or whatever, and they're coming back. I think that scenario is probably very safe or relatively safe. There's nothing indicating that they wouldn't be able to come back. They're not applying for a visa. It's clearly not a new visa that they're applying for, so they're probably fine. The rest of it, though, there's a lot of unknowns that if you can stay put, at least till this is clarified, that might be for the best. And then the other big news was the gold card. So the gold card that they're proposing is it's not an investment, it's a donation to the US government of $1 million as an individual or 2 million by a corporation to get a green card through either the EB1 or EB2 category. Is kind of how we've learned from the Commerce Secretary that that's what they're planning. And at one point, they indicated that they're going to replace EB1 and EB2. Well, I will say replacing EB1 and EB2, I can't imagine a court saying that that's going to be challenged immediately. And it's hard to imagine a court not agreeing that the president doesn't have that authority. If he wanted to kind of modify the regulations to allow one of the ways to qualify as extraordinary ability is if you can afford $1 million, you must be extraordinary. I still don't know, but maybe, at least I don't think the courts will necessarily instantly strike that down. Um, so that again, this is brand new. I had someone today who was looking to do EB5 and they were asking about this, and which is safer. EB5 is a known quantity. Um, I will say that if you are Indian and you do not have an older priority date, um, getting EB1 is good. Don't get me wrong, it's great. but you're still going to have to wait a few years for the green card because the priority dates are not current. And I don't see how the president can change that. That those are set by statute. So unless he gets all of these things that I'm saying he can't do, what I mean is he can't do without Congress passing a law, which even with control of both houses of the government, it seems unlikely. Then there's also the platinum card, which they've had less detail. That's going to be $5 million investment, and you're going to be exempt from non-US income if you spend no more than I think 270 days in the US. Um, so yeah, again, it's kind of like the EB2 and EB1. He had indicated at one point months ago that it was going to replace EB5. Again, there's pretty much no way that he can do that without Congress. So if you wanted to add this to EB1A, which is I think the only way he could even remotely conceivably do, I guess he could try, but I don't. They did. It looks like they're acknowledging that they need Congress for the platinum card because it involves tax law. So that part they seemed set on, but we're gonna have to see. There's so many unknowns at this point, and whether anyone's ever gonna get one of these gold cards or not remains to be seen.
Yeah. This is a good question. It's a question that I had also that came in. Do you think the EB5 will be scrapped? I thought the administration was trying to do that and replace it with the gold card.
They can't without Congress acting. They cannot do that. I don't. Even though the Supreme Court has some very Trump friendly Supreme Court, I can't justices right now. I cannot imagine that they're going to say yes. You're allowed to override congressional statutes passed by Congress. That would basically mean Congress has no function whatsoever. Um, so I'm not worried about that. If he wants to scrap the EB5 program, what it would look like would be waiting for the regional center portion at least to expire, which it's set to expire in 2 years. And anyone who's investing now through September 30th of 2026, I believe, they're grandfathered in, so they would still be protected, even if it did later on expire. But so in 2027, September 30th, 2027, if he doesn't renew it, if Congress doesn't renew it and he signs it, then the regional center program would die. But there are a lot of people, a lot of Congress, people in Congress, people in the Senate who have a lot of incentive. They want to keep it. And a lot of these rural projects are in red states, Republican controlled states. So he's going to either have to fight, you're either as a senator going to have to vote against your own constituents' interests, or you're going to get into Trump's ear and be like, look, I cannot sell this to my constituents. They're making money off of this. Our state is making money. We need this. And he may come around. But again, there's a long time between now and then. But I am not worried about EB5 going away anytime soon.
Got it. Okay. Okay. Anything else that you wanted to cover when it comes to non-immigrant visas and investing? Aside from EB5, we're going to do a whole separate episode just
Right.
on
No,
that.
no, that's fine. I nothing in particular is coming to mind. Again, I think we're living in some very unusual times from an immigration standpoint, but even with everything we've seen, I have not seen anything directly, trying to impact how foreign nationals can lawfully passively invest. So I don't think I still, even with everything going on, I'm not too worried about, all my clients that are doing different kinds of investments. Um, it, I don't see any reason why this would be even on their radar. And if it was, I don't see how they could say the person's been somehow violating status, other than the fact that anytime you're dealing with a gray area, it's certainly open to interpretation. But I wouldn't lose any sleep over it, frankly.
Okay. Another question came in. As a Canadian citizen, I'm slightly concerned about USMCA renegotiation coming up and TN going away. Does that also need congressional approval?
If they wanted to get rid of it, um, God, I think the Senate. may have to ratify. I honestly don't recall. Um, it's been a long time since I've looked at that, but I if look, if you wanted to stop TN, you'd have to check, but there probably are provisions that would let him, to a degree, get rid of that a lot easier than some of the other categories because the TN is not based on statute; it's based on treaty. That being said, I haven't heard any rumbles about getting rid of the TN. The current policy is based on it's his, he negotiated. It was from the TM perspective, it's identical. Nothing really changed. But he still has his footprint on it. Um, have things changed that much since last time? Maybe. But at this point, I haven't heard anything about that potentially going away.
Okay. And so, in summary, really, number one, all non-immigrant visas, H-1B, L-1, E-1, E-2, J-1, I think, all kind of the same in that you generally have to just be passive in your activities when it comes to investing in business, and passive in reality, right? Like you could be a general partner, but as long as you can prove you didn't do any actual work and you hired someone else to do it, or a partner did it, or any other entity, it shouldn't really be a problem. That's number one. And then number two is, as with all things, a lot of things in life, before you think about doing anything, if you're unsure, just ask an immigration attorney. Does that sound about
Yeah, I think that that's all fair to say. Again, there it's very hard to give definitive answers in a lot of things in immigration. But so when a lawyer gives you kind of, well, maybe this and maybe that, there are reasons for that. It's not they're trying to just cover themselves. There are
Yeah.
reasons. But with these passive investments, I've never seen anything to indicate that the government's going to care at all about it from an immigration standpoint.
Okay. Well, that's all that I had come to mind for now. And again, future episode coming for EB5. So, folks listening, keep an eye out for that. Joel, what's the best way that our listeners can reach out to you, learn more about you, and connect with you?
Um, I mean, Murthy.com, our website is very popular. If they have EB5 questions, they can email EB5, all one word, at Murthy.com, and those come directly to me. So that's a way if they're just looking, look, they want to talk about their specific issue and they want to schedule a consultation with me, they can just do that through the front desk because they control my calendar. Yeah, so those are probably the safest ways.
Okay, so Murthy.com, the website, and then for EB5 specifically, it's just EB5 at Murthy.com.
Correct.
Okay. Okay. And then besides EB5, any other areas that you focus on heavily?
I do. So I primarily do EB5, E2, L1s. I have done some entrepreneur parole visas, which is like a very rarely used program. It's extremely hard to qualify. But I handle all those when they in the rare cases that they do come in. And I handle other things. I do a lot of I do TNs. I do plenty of H-1Bs. It's just from the entrepreneur standpoint, anything related to entrepreneurship typically is coming to me.
Got it. Okay. Okay. So we'll upload this to YouTube and include your contact information in there as well so that folks can reach out to you. We'll have a follow-up episode. And for those of you listening at home, thanks for joining today's episode of Investing for Generational Wealth. Definitely a very unique guest. Thanks for joining us, Joel, today and giving us a lot of insight into the gray areas and the intersections of investing, which is sometimes typically more cut and clear, but immigration, which is the gray area. So
Right.
we appreciate you taking the time.
My pleasure. It was great being here.
Okay, thanks everyone. And until next time, continue to invest for generational wealth.